All right, let's jump into the lecture. It shouldn't be a long one today. What we're really trying to do with our discussion today of rules and rule statements is to provide a conceptual framework, which apparently is one of my favorite phrases, to your analysis and evaluation of legal writings. So when you're reading a court, the court may say that the rule is blah blah blah. If they don't, you have to find it, no matter if they earmark it like that or not. And sometimes it helps to know what kind of rules they might use and to look for those phrasings in the text of the case. But even more importantly, when it comes time to write exams and exam answers and practice answers, knowing what kind of rule you're dealing with will point you in a particular direction. So, formally doing rule analysis all the time really isn't going to be the best way to study. It is, however, the kind of thing that if you're aware of, you can take a better advantage of when you are writing those answers. It will be a much easier experience for you if you understand the game that's being played, and the game that is played starts with the rule, obviously. That's where all of the analysis and your answers will come from. So, this differs. Well, let me take a step back and say that generally, the kind of writing that you're learning to do in legal research and writing, LRW, is very effective for that area of law. And really, for any legal writing you'll be doing, the tools that they're teaching you in LRW will have great utility. However, that's not really how you want to write exams. You have a different goal in exams. And I teach this in my other courses too, but it's one that if you haven't heard, it's a general truism in law, is anytime you write a legal document, think about for whom you're writing the document and what purpose you have in writing the document. In LRW, of course, you're writing to determine the outcome of a case or to persuade a judge or a partner, depending on which project you have in LRW, to decide a case in a particular way. You present the facts in a favorable manner to your side. I'm not saying you make up facts, of course. You know all the things they teach you in LRW. I'm not trying to contrast with that. But you're trying to do persuasive writing in LRW. In an exam answer, think about it just for a second. What are you trying to do? And this is me giving you a second to think about it. If I was in class, I'd stare at you until someone said something. So be happy we are in class. But if you thought about it for a little, your exam writing is you're writing to show your professor that you know the rules of law relevant to that area of law, and more importantly, that you know how to use those rules. It's the use of the rules to break down and reconstruct them in use that really demonstrates to the professor that you have a firm understanding of this area of law and that you are writing an answer that checks all the boxes for your professor. So a lot of the rest of the semester, in a lot of ways, is geared in legal skills, is geared towards having you conduct that exam writing so you are confident in walking into an exam, knowing exactly what to do, knowing that even if you get stuff that you may not be familiar with, that you can go back to basic tools that you've learned here and elsewhere and be able to start to attack the question. Things will come to light as you address the issues in the question, and you may pick up a full understanding along the way that you didn't have when you started. But the worst thing you could do is just panic and say, oh, damn, I don't know what I'm doing. This question's totally out of the blue. Just say, okay, it's another exam question. Let's see how I analyze it. What kind of rule is it? What can I state the issue to be in light of that rule? And all of a sudden, you're off towards the IRAC method. IRAC, as I'm sure you've heard, it stands for Issue, Rule, Analysis, and Application, and Conclusion. There are certainly different forms an exam answer can have. CREAC was one that some professors prefer. IRAC is the sort of standard for the area of legal exam writing. You should check with your professor. Ask them if they prefer IRAC, CREAC, or some other format, and I think you'll get a straightforward answer from them. Most will probably prefer IRAC, I expect. So we will be turning to IRAC writing in future classes to talk about the structure of IRAC, and the way you generate it, the way you include counter arguments, blah, 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 alternative outcomes, all that kind of thing we'll get into later. Today we're just focusing on the rule part. Again, because if you have these approaches firmly in place, then you will be able to tap into them while you're. So, what is a rule? I pause to give you time for reflection. Anyway, a rule is the legal authority which, when applied to a set of facts, will determine the outcome of the legal issue. Yeah, I mean, that is at the highest level what a rule is. It tells you what to do in a new situation, with, i.e., a new set of facts. I forget what I started that sentence, so let me start again. The legal authority provides you with the rule that you can apply to a new set of facts and determine the outcome of the new legal issue. But the rule itself isn't necessarily tied to the facts, of course. It's been pulled out of a case and has become part of the common law. It's come in a lot of different varieties. There are simple rules, and I'll give examples of all of these in the next slides. Elemental rules, factor rules, which are very common in law, frankly more common in upper level classes, just because the more complex an area of law becomes, the more it falls on the court to weigh various factors to arrive at an appropriate solution. And those factor rules often just tell you what the important things to consider are. Alternative rules, rules with exceptions, which feel like alternative rules but are really different, and then combinations of the above. Simple rule. The issue is, did a battery occur? And so what kind of rule do you use to answer that? If A, then Z. So an action in battery shall be brought within 1 year after the cause of action accrues. This is a statute of limitations, but it is an example of a simple rule. It's not an elemental rule, which may actually recite the elements of the battery rule. In this case, perhaps the issue should be more tightly phrased as, may an action in battery be brought? But here, it is still the same rule that applies. It's a simple rule. If it's been less than a year, then B, a cause of action can be filed. Shall be brought, rather. In this instance, it's shall be brought. It's not optional. Okay. An elemental rule is one that you're probably most familiar with using these days. And it includes most of the intentional torts. So if A, B, and C are present, then Z. Burglary is a good example. You'll get this in crim law, but it's the breaking and entering of a dwelling of another at night with an intent to commit a felony therein. So, what do you have to do to have a burglary? Well, there has to be a breaking and an entering of a dwelling of another. You can't burglar your own house. At common law, it had to be at night, so you couldn't be a daytime burglar. And you had to have an intent to commit a felony within, and that could be a property-based felony or violence-based crime against the person, whatever. It's some kind of felony. So that's how you determine if all of those are present, then yes, you had a burglary. Unless you're the Hamburglar. I think he functions according to different rules because he seems to function mostly during the day. He had to earn his name somehow, so I might look into that. I don't know how he's a burglar of any sort. Anyway, Here we are onto the factor rules. I love factor rules just because this is really where lawyers have the most flexibility to offer to put their legal skills on display. Here's an example of a factor rule. To determine whether the breach of contract is material, the courts look to the following factors: the extent to which the injured party will be deprived of her contract benefit, the extent to which the injured party can be compensated for that lost benefit, the extent to which the breaching party will suffer forfeiture, the likelihood that the breaching party will cure the defect in her performance, and the extent to which the breaching party has acted in good faith. None of these factors individually is controlling. If you look at the phrasing of the rule itself, it says the courts look to the following factors. You'll also see phrasings like courts are instructed to consider the following factors which may be helpful in determining the outcome. These provide a lot of flexibility to the court to adjust the rule to the facts. If you think about breach of a contract, there's so many ways it can happen. You really have, and whether that breach is material, as this rule is assessing, really depends on so much and how the parties are situated relative to another. The impact of the breach is going to be very substantial for one, so the likelihood of cure could be different. All sorts of things. Maybe there's no forfeiture issue in your case. Maybe there is, but this allows a court to sort of weigh these things. And anytime a court is weighing things, deciding which factor is more important than the other and should be the dominant factor in producing the outcome, then you have the most play as an attorney, because you can make arguments, with, of course, supportive precedent and everything else, to be able to sway the court over by making compelling arguments about your poor party, or, this is the reason why these three factors are most important. My party, who is the injured party, will be completely derived of the contract benefit. The fact that this factor is in the rule means it's important, and it's of paramount importance to my party, my client. And so those kinds of arguments, and much more elaborate ones, can be made with these factor tests. You'll, I hope, learn to love them. There are alternative rules. If A or B, then Z, or if Z, either A or B. You could phrase it in the alternative. Obviously. That was actually a bad pun, and I'm embarrassed. But regardless, an alternative rule, here's a basic example. A plaintiff in an action for breach of contracts may be awarded damages for the harm caused by the breach. Perhaps causes the harm caused by the brief. Don't write those briefs. The harm caused by the breach. Or obtain an order requiring the breaching party to specifically perform the promise. So what is this? This is, it's sort of a backward phrasing of an alternative rule, but it gets to the same thing. It's only the phrasing, it's backwards, really, though. You're just saying if you have damages, which of the two can you get? You can get damages, which in this case would be Z, in either way, right? You can get specific performance, or you could be awarded legal damages. Just an alternative. So the combination rule, these are very, very common in upper level classes too. I present here a great combination rule from patent law, if you so enjoy it. There's such a thing as called an on-sale bar in patent law. It doesn't matter what it is. There's an example of the rule, the product that was subject to a commercial transaction or offer for sale. Okay? That was the first one. That must be answered. That, therefore, that's a good alternative rule, actually. You could, how do you say if something was, this element was satisfied? Well, there was a commercial transaction or there was an offer for sale. And you need to satisfy two elements. So let's look at the second element. The second element is a product was ready for patenting. Then nobody knows what that really means, frankly. Um, Even in patent law. Sorry for my daughter in the background there. But so to establish this, you can do it of one of two ways: reduction of practice or a disclosure. But anyway, you could see again, this is an alternative phrasing. You combine the two and you end up with a combination rule. Here's another example. It may be a little dated, even though it was very popular last year at this time, and I like it too much to let it go after just 1 year. So here's another example of a combination rule. Based on its tempo, will Lizzo enjoy dancing to a particular song? Well, if the tempo is slow, then no, because Lizzo feels that slow songs are for skinny women. Bracketed, right? But what if, alternatively, the tempo is fast? Well, then yes. She feels the fast song is more appropriate for her physique, to paraphrase the lyrics. So it's just another combination rule. I doubt Lizzo thought of it in that way, but nonetheless, if you think of, you can break down things across your daily life and see what kinds of rules apply. But you're doing it all day in your readings anyway, so be satisfied with that, I think. And I think as a final example, we have rules with exceptions. If A, then Z, unless B. And as you get into defenses to intentional courts, you'll start feeling these very well because you see them a lot. A person who's been induced, here's about fraudulent misrepresentation, right? A person who has been induced by fraudulent misrepresentation to transfer title of property may recover that property from anyone who subsequently possesses it, unless the subsequent possessor was a bona fide purchaser. He's bona fide. If anybody knows what that's from, let me know. Extra point. Anyway, so you see the underlying part is clearly the exception. And you could construct these a lot of times, and sometimes they're more tightly tied to the rule. Sometimes the alternative feels like a separate rule, like defenses to intentional torts. But really, it comes down to a person who has, without stating all the elements, a person who has done A, B, and C has committed a battery unless they did so in defense of themselves, right? And then you have to go through the elements of the defense of self or defense of others, whatever the defense might be. But so that's where it's a little more spread out. This is a little tighter rule with the exception built in, but it's the same conceptually because you see these things play out over the course of a case, and it's just a very easy and common phrasing of rules. Sometimes you'll see unless, however, all those kinds of things sort of indicate that there's an exception coming up. Okay, let's do an example. This is section 1 of the Restatement of Contracts. I think the second. This is an example. Section 1 from the Restatement second. I always thought that was funny. Why not put it at the front, right? I've never understood that. Why isn't it the second restatement? I'm sure there's a very good reason. I just don't know it. And it always struck me as we were just trying to be too fancy. Anyway, let's do this example. So contract is defined in section 1. And it says a contract is a promise or, ding ding, a set of promises for the breach of which the law gives a remedy, or the performance of which the law in some way recognizes as a duty. You've broken this down in contracts law already, I imagine. So let's break it down sort of from a rule perspective. Okay, there's just the restating of the same material. Here's the rule or type. It is a combination rule. And the reason you can see that is the or. The second or, actually. The second one, the first or is about what can make up a contract. the second or is an alternative way of establishing that contract. So it's a combination. And it is elemental. It means it could be, it's basically elemental. There's just one or two elements, and it is in the alternative. What's the result? A contract exists. The rule parts, there's either a promise or a set of promises. And the law gives a remedy for the breach, or the law recognizes the performance of the promise as a duty. Okay? Those two are the alternatives, the promise or a set of promises. And those are alternatives for the second element. So you have two broad elements here, the first part being establishing whether there's a promise or a set of promises, one of those two alternatives, and then one of the following two alternatives. So it's elemental in that you have to satisfy one of the first alternatives and one of the second alternatives. But it's all... I should have phrased that differently. Let me do that. So it's an elemental rule in that you have to satisfy one of the first two options and one of the second two options, making those subparts of the rule alternatives and the overall rule to be elemental. A1, A2, B1, B2. You have to satisfy one of each of the letters to have the rule be appropriate. And I included fancy, helpful boxes in different colors to show that these are the elements. Oops, I'll go back. I won't go back because that'll delete the sound. I've learned that along the way. So, why is it important to do this? This feels pedantic, doesn't it? This feels basic high school, middle school stuff. But why is it important to identify the rule types and deconstruct their parts? It's to prepare for the analysis and application. What do you have to talk about in an answer on an exam? Well, you have to appropriately analyze the rules and facts so that you come to an appropriate conclusion. And to conduct that analysis, you have to recognize what you have to discuss. You not inherently, because you've worked to do it, but you already know and recognize a lot of the elements. But now that you have a slightly different, maybe elaborated understanding of the rules that courts routinely use, you'll be able to feel a little better about applying your analysis, because you'll be able to say, okay, did I talk about both alternatives here? It's not something you have to raise in an exam. You don't go in and say, hey, this here's a combination rule, and I'm going to break it down for you and then tell you how it works. You don't have to do that. You don't have time to do that, and most of your professors want you just to cut to the chase. But when you are constructing your answer, you're going to be essentially deconstructing the rules, taking it apart into their component parts, analyzing each of those component parts, and subsequently writing the answer out. In a way, all of this is getting down to the idea that there's a way to present your answer that law school professors will be happier to read. And part of that is making sure you address the elements of the rules or the factors of the rules. So your assignment for next week is straightforward. It is, there's a rules worksheet posted on Blackboard, and it is, I think it has 3 rules in it. Just break them down and say what kind of rules they are. It's just the process of deconstruction. And again, this isn't a rhetoric or logic class. This isn't the end result. But it puts you in a position where you will feel more and more comfortable in generating answers to academic legal test questions. And as you incrementally learn this information, what the important things you have to do, like write papers and write exams, will become much easier as you go along as a result. So complete the rule worksheet and return it to your mentors. That'll be great. So that's it for this week. Be well, be safe, and I will see you around. I'm in the building on Thursdays. So if you see somebody with my haircut around on Thursdays, say hello. Thanks.